Michael Popok, Legal AF. Even this MAGA Supreme Court finds that Clarence Thomas has gone too far when it comes to gun rights and his absolutist approach that everyone has the right to bear arms without regulation or restriction unless you can find an exact historical twin for a regulation in 1791 or in the early 1800s. Even this MAGA Supreme Court believes it's gone too far, and in an 8-1 decision, in the new decision of Rahimi, United States versus Rahimi. And I'm going to tell you the facts of Rahimi and why he was found to violate a federal law that someone who's subject to a domestic violence restraining order should not have the right and has forfeited the right to bear arms. We got into this mess that now had to be clarified and rolled back by Chief Justice Roberts because Clarence Thomas wrote the majority decision in Bruin versus the New York Rifle Association, in which he ruled basically for the first time for the United States Supreme Court that an individual had a right, a Second Amendment right, to have arms outside of his home. Once that was written, and because Clarence Thomas and the others, Gorsuch, Kavanaugh, Amy Coney Barrett, and others, and even Roberts thought it was okay to have this as the test. Can we find an exact twin in history, whether it's the 1790s or the early 1800s, for this particular gun regulation? And if we can't find it, we can't have a modern gun regulation to match. That was the historical tradition, new test that the right-wing MAGA conservatives use to try to undermine our constitutional rights and civil liberties. Every time you hear historical traditions, and when you see judges on the Supreme Court searching for where in history has there been an identical regulation, you know you're in trouble. Even Amy Coney Barrett this term, just a week ago, in a decision involving copyright law, and a person who tried to copyright "Trump is small" and put it on T-shirts, took a pot shot at Clarence Thomas. I think that was the canary in the coal mine for this decision, Rahimi, that just came out, because she took on Clarence Thomas front and center and said, your use of historical precedent as a substitute for judge-made tests has its limits and is improper and hamstrings our ability to modernize society. Even Amy Coney Barrett said that. Now, in this current decision in Rahimi, they have refashioned just 2 years later and fixed the problems of Clarence Thomas's Bruin's decision. And the only person that said that a domestic violence abuser has the right to bear arms and have a gun in this decision is Clarence Thomas, because he has not found a regulation, a proper regulation on gun rights to ever be effective unless he can find an exact duplicate in history. And his history is 1790s and 1800s, and without any context whatsoever. He never recognizes that slaves, before they were even Black Americans, were treated as second, third, and fourth class citizens in the society. That women were not treated as equals. They did not have the right to vote. They were treated as chattel owned by their husbands. Domestic violence, beating or even killing your wife or someone in your family, was not a crime in many states back in that period of time. So how could a restraining order on somebody committing domestic violence, which is a federal law now, how could we ever find a historical twin that's identical? It's so bad that even Judge Roberts, Chief Justice Roberts, said, we've made a mistake. Or as Ketanji Brown Jackson said in her concurrence, the fault is not with the trial court levels. The fault is with this court, the United States Supreme Court, that we did not give clear direction on how to apply our decision in Bruin, or the majority decision in Bruin. And what now Justice Roberts has said is, we did not mean to suspend an amber historical tradition. You don't have to find an exact duplicate, Judge Roberts wrote. You don't have to find an exact duplicate for the regulation that is being challenged back in the 1790s. You just have to see if the new law fits with the tradition, the principles that undergird the historical tradition. Now, I don't agree with the historical tradition model or framework of analysis being used at all. But if we're going to use it, at least we got the United States Supreme Court in an 8-1 decision to instruct the lower courts on how they're supposed to apply it. Don't look for exact identical equivalency. That's what Clarence Thomas wants. He wants, if you can't find an exact statute that matches, then this regulation must go. That's why he's on the wrong end of history and the wrong end of this decision, arguing that people that commit domestic violence should have guns. Let me describe to you, before I get into the findings and the ruling of this order by Justice Roberts, that was joined by 7 others, but they all did concurring opinions or joined somebody's concurring opinions. Gorsuch, Kavanaugh, Amy Coney Barrett, Sotomayor, they all wrote concurrences or joined in each other's. Yes, they ruled 8-1, but there's a lot of division underneath it. And as I said, Amy Coney Barrett raised the red flag 2 weeks ago when she said, what are we doing with historical precedent? She had obviously seen the draft of Thomas's dissent, which I'm sure he circulated as an attempted majority opinion, and was like, I'm going to take this on right now. So I give her slight credit, although she's always on the wrong side of history as far as I'm concerned with her voting. But she did take on this historical history analytic framework that is so troubling. And so let me just describe for you, as Justice Roberts does, who Clarence Thomas believes should continue to have a weapon. His name is Rahimi. And here's how he lost his right, his Second Amendment right. In December of 2019, Zaki Rahimi, this is from the decision on page 1, met his girlfriend for lunch in a parking lot. And she was also the mother of his young child. During the meal, they began to argue, and Rahimi became enraged. When she attempted to leave, he grabbed her by the wrist, dragged her back to his car, and shoved her in, causing her to hit her head against the dashboard. When he realized that somebody had seen the altercation, he paused to retrieve a gun from under the passenger seat. He took advantage of the opportunity to escape. He fired his gun as he fled. And later he called the woman that he was abusing, the victim, and warned her that he would shoot her if she reported the incident. That's not the only thing that this guy now armed has done and that Clarence Thomas is defending. He's also defending this person who, when the victim went to court to seek a restraining order, in her affidavit, she recounted the parking lot incident and the conduct that endangered her child. And then when the state court of Texas issued the restraining order, finding that he had committed a family violence and he posed a credible threat and to the physical safety of the victim, and took away his right to have arms, he violated that order by approaching her that night. Right? He also began contacting her through social media accounts. He threatened a different woman with a gun. This is on page 2 of the decision, resulting in a charge of aggravated assault. But we're not done. Again, this is who Clarence Thomas believes and is defending and has the right to bear arms. While he was under arrest for that assault, police identified him in Texas as the suspect in 5 additional shootings that all arose from him being an illegal drug dealer. After one of his customers started talking trash, this is all in Robert's pen. Okay, this is who Clarence Thomas is defending. During a drug deal, Rahimi drove to the man's home and shot into it. While driving the next day, he had a car accident and proceeded to use his gun to shoot at that car. A few weeks after that, while he was speeding, he hit the brakes and cut across traffic to chase a truck in a road rage incident. Once off the highway, he fired several times towards the truck and at a nearby car. 2 weeks after that, he was dining at a burger restaurant. When the restaurant declined his friend's credit card, he pulled out his gun and shot into the air. I mean, and to Clarence Thomas, well, can't find an exact historical precedent that's going to support taking away a domestic violence restraining order person and his right to bear arms. I mean, that was such a shocking, absolutist assertion under his Bruen decision that even the other justices who mainly side with Thomas on everything were like, nope, that's gone too far. I mean, you know you've gone round a bend and taken the train to Crazy Town when you can't get your other MAGA to join in on the fun. Let me read to you from what Judge Roberts had to say and the others agreed with. And Sotomayor applauds as finally giving proper direction to the lower level courts after the mess that Clarence Thomas made, and the rest joining him in the Bruen decision from just 2 years ago. They said that that the court in Bruen has left the impression to the rest of the trial court level, which is their fault, that you have to find that as exact historical twin. So what he said was on page 5 of his order, we've held that the right to keep and bear arms is among the fundamental rights that is necessary to our system of ordered liberty. This is Justice Roberts, and talks about the American Revolution and our use of guns, and that the Second Amendment, however, is not an unlimited right. At the bottom of page 6, the judge says, in Heller, our inquiry into the scope of the right began with constitutional text and history. In Bruen, this is Clarence Thomas's decision from 2 years ago, he wrote it, we directed courts to examine our historical tradition of firearm regulations. Run for the hills when you hear historical tradition. We explained that if a challenged regulation to the second, regulating the right to bear arms, to have a gun, fits within that tradition. You see what he's done with a sleight of hand? He kind of elides the problem by saying now we're only looking at tradition and principles of tradition, not exact analog laws. Roberts continues, we also clarified that when the government regulates arms-bearing conduct, as when the government regulates other constitutional rights, over to page 7, it bears the burden to justify its regulation. Now, here's where he basically concedes almost a little bit of a mea culpa that they went too far 2 years ago. Roberts says on page 7, nevertheless, some courts have misunderstood the methodology of our recent Second Amendment cases. Right. To which Ketanji Brown Jackson in her concurrence says, we did it. They misunderstood because we gave them unclear direction. Justice Roberts continues, these precedents were not meant to suggest a law trapped in amber, right? Meaning it's supposed to live and breathe. As we explained in Heller, for example, the reach of the Second Amendment is not limited only to those arms that were in existence at the founding. Rather, it extends to all instruments that constitute bearable arms, even those that were not yet in existence. By that same logic, Roberts continues, for the majority, for the 9-to-1 majority, 8-to-1 majority, the Second Amendment permits more than just those regulations identical to the ones that could be found in 1791. Holding otherwise would be as mistaken as applying the protections of the right only to muskets and sabers. As we explained in Bruen, the appropriate analysis involves considering whether the challenge regulation is consistent with the principles that underpin our regulatory tradition. That's not what Bruen said. Bruen said you have to find an exact historical comparator. Now, Roberts has basically said, that's not what we said. It is exactly what he said. Now he's saying you just looked at tradition, and if you can match up as best you can traditions and principles, that's okay. Why and how the regulation burdens the right are central to this inquiry. For example, he continues, if laws at the founding regulated firearm use to address particular problems, that will be a strong indicator that contemporary laws imposing similar restrictions for similar reasons. See, similar is enough under the new Roberts theory. And this is the problem that, of course, Clarence Thomas said. No, he said, that's not what we said in Bruen. We said exact historical comparator. I'm an absolutist when it comes to the Second Amendment. So absolute that he's defending this crazed drug dealer who abused his girlfriend and the mother of his child and then went on a shooting spree while he was under a federal restraining order that restricted his right to bear arms. I mean, if that is not an example of the appropriate use of regulation that our founding fathers and framers of the Second Amendment would be proud of, I don't know what is. And this is the problem with the historical comparator model and analytic tool that's being used by the right wing. Let me just give you the tricks here, the decoder ring for the Supreme Court. When you hear the Supreme Court right-wing MAGA ignoring the facts of the case, that's because they don't like the facts of the case. And they want to make new law regardless of what the facts of the case are, even though that's not the role of an appellate court. They just want to ignore, let's not, as Alito has said during certain oral arguments, let's not get bogged down in the facts. Appellate courts are supposed to accept the appellate record coming up from the lower level and not make new facts and accept the facts and make law and decisions based on those facts. So that's the first thing. When you hear them ignoring the facts, you know they're going to make a judicial activism law that has nothing to do, is unmoored completely from the trial record. That's one. Secondly, when you hear them start, as they've done in the last 3 or 4 years, to talk about the historical tradition and precedent of the United States, and even require an exact duplicate in history, you know they're going to be against the regulation. That's your second tell for the United States Supreme Court. And the third one is when you see them recite the facts, like the terrible facts of Zaki Rahimi, who went on this shooting spree and abused his girlfriend. When you see those gory details that are being repeated by somebody like the Chief Justice, that's because they've had trouble internally in trying to get the votes to support the majority decision. And they want to ostracize and put out on as an outlier somebody like Clarence Thomas on an island to say, this is the guy you're supporting. Now, if they wanted to just continue Bruin's analysis and just say, sorry, domestic violence wasn't a thing or a crime back in the 1800s because women weren't treated equally and they were abused regularly by men without repercussion. Sorry, we can't do anything about that now. You'd see no reference to the facts of the case. We would say, we don't get bogged down in the horrible details of Mr. Rahimi. So you see the tricks. These are tricks. This eliding, this conflation is tricks of the trade. It's in the toolbox or bag for right-wing MAGA. And I've just started to unpack it here for you through this Rahimi decision that just came out. So the headline was, so even this Supreme Court 8-1 rolls back, Bruin and the decision there and finds that domestic violence abusers who are subject to a restraining order can't own a gun. For now, even Roberts and the rest of the court basically said that when that issue clears up and the person is responsible again, he can get his gun back. So to even the MAGA, I don't want to say they're covered themselves in glory here. Even the right-wing MAGA Supreme Court believes there is a world in which Rahimi is somehow rehabilitated and gets to get his guns back. He gets his constitutional fundamental right back. Once he's done. It's almost like felons who serve their time get their right to vote back. So focus on that as well. That is this decision. I'm going to continue to follow it and break down these constitutional decisions right here on the MeidasTouch Network and on Legal AF. Follow me, Michael Popok. It's easy. Go over to the YouTube channel for MeidasTouch. Look for Michael Popok under contributors and under playlist, and I'm right there. And then you can follow me on Legal AF on Wednesdays and Saturdays at 8 p.m. Eastern Time, right here on MeidasTouch. It is a podcast devoted to the intersection of law and politics, and I think you'll enjoy it. We curate the top 4 stories or 5 stories at that intersection and bring it to you, like me, a lawyer who knows what he's talking about at the intersection of law and politics. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.